Mr. Mercer.
May it please the Court. Mr. Derr was convicted of rape and related offenses following a jury trial that turned solely on scientific evidence. There were two categories of scientific testing that were at issue. The first were results of a serological exam of a vaginal swab that purported to show the presence of semen and sperm. And the second were the results of DNA testing of vaginal swabs. The state introduced the results of these scientific tests through the testimony of a surrogate expert who did not participate in directly or indirectly with any of the scientific testing. In this way, the state was able to introduce the sole evidence of identification in this trial while shielding the forensic analyst who conducted the exams at issue from any cross-examination.
Refresh my recollection from having looked at this. Did Dr. Lutman, she was a PhD, right?
No, she's not a PhD.
Okay, so Agent Lutman.
Although I don't believe she was a special agent, but she worked for the FBI.
Did she acknowledge a lack of familiarity with testing protocols that were in place at the time the original serology was done?
She absolutely did, yes.
How about when the testing that resulted in the cold case match?
The 2002 DNA analysis, Ms. Lutman was employed at the FBI, but with a different team that was not involved in any way with the 2002 analysis of the rape kit. She wasn't a technical reviewer. She wasn't a supervisor. She had nothing to do with that analysis.
She did not acknowledge she was unfamiliar with the testing protocols that employed by the FBI.
That's correct. She did not. But I think, Judge Harrell, what's significant here, if we go right to the question of whether the DNA test results from the 2002 analysis are testimonial statements that would require the state to produce the analysts who generated those results. The definition of testimonial is one that is functional. The question is whether information is generated in anticipation of a criminal prosecution, and that during the process there's an exercise of discretion and judgment and interpretation, which are the hallmarks of testimonial statements that must be subject to the crucible of the Sixth Amendment right to confront and cross-examination, to weed out not only the incompetent analyst but also the fraudulent analyst. Now, with regards to whether the raw data is actually a statement of the analyst, what's important here is that when Ms. Lutman, although she was familiar with the protocols in 2002, she had to rely not just on the raw data, but also the statements of the testing analyst from 2002. And in fact, in the transcript of Ms. Lutman's testimony from the third day of trial, just the court's rulings are in the extract. This is in the record. But at page 33 in the record, Ms. Lutman is asked, you did not, at the time referring to the 2002 analysis, you had no personal involvement. Right. No, I did not. And so you weren't there to ensure that all the protocols were followed, right? No, I was not. Question. And in fact, there is a thick stack of protocols that have to be followed in the FBI lab, isn't there? That's correct. And so you're simply trusting that these protocols were followed, aren't you? Answer. Trusting and also reviewing the notes that were produced in 2002 that are part of the case documentation. So the important point here is that for Ms. Lutman to depend on the raw data that's generated by the DNA testing in 2002, she necessarily has to rely on the statements of the testing analysts who conducted that analysis.
What did those notes say?
Well, the notes document the multi-steps of the DNA analysis that are undertaken by the analysts in 2002. So it goes from extraction through separating the different male and female sections, as they refer to it, taking it through a centrifuge, through amplification, through annealing, re-annealing. And I lay out in our briefs the complicated steps that are followed here. This is not just throwing a switch and then out spits this data.
Is it conceivable that there could have been an error in judgment, or is it more likely that there would have been an error in some sort of contamination?
Well, I think it's both, and which is precisely why there needs to be cross-examination of the analyst who conducts the testing, because there's really three categories of testimony. There's testimony about chain of custody, there's testimony about the test itself, and then there's also testimony about the interpretation of the results. And here, what's significant, Your Honor, is that the documented instances of fraudulent activity in the context of DNA analysis, one of which occurred precisely at the lab where Ms. Lutman worked, involved situations where the DNA analyst was fabricating data. That occurred at the FBI, Jacqueline Blake.
Precisely what? How did she? It was a woman, wasn't it?
Jacqueline Blake, yes.
How did she fabricate that data? Which parts of the multi-step process did she?
In Ms. Blake's case, what she was doing was fabricating the negative controls, which are essential to determining a global contamination event. Negative controls don't, so it's a deviation from the protocol, and therefore the test results are invalid.
And specifically, what were those negative controls?
Well, the negative controls are run with every batch of samples that go through the DNA analysis. So, for example, the negative control is a test tube filled with some of the chemicals that are used that are supposed to have no DNA at all in them. And so at the end of the DNA process, those are run through the electropharogram to see whether there's any DNA in a test tube where there shouldn't be DNA. It's one way of detecting possible global contamination. It's not foolproof by any means. But what's significant here is that the model that the FBI uses of bringing in this talking head surrogate expert witness is precisely the model that was used in Jacqueline Blake's situation. So Jacqueline Blake never had to be faced with the deterrent effect of cross-examination. Rather, some other person at the FBI, who's presumably very solicitous of her work because they're colleagues, comes in and testifies about the results that Ms. Blake generated.
Mercer, is your argument dependent upon whether the FBI had a problem so many years ago? Wouldn't we be still here on any lab that had never had any problems on any? Do you want an opinion that's based upon an error or something that happened in a lab? You're really not arguing.
No.
My understanding is that we could have the most pristine lab that had been certified by every country in the world, and that, people had put their imprimatur on and whatever, and we'd still be here. Isn't that correct?
Oh, I think so. I think the point of the situation with Ms. Blake, which occurred right around the time when the rape kit here was testified, which has occurred in other labs, for example, at Cellmark.
I understand that, but the whole issue in terms of the Supreme Court cases from Crawford on to Menendez-Diaz did not depend in any way on error. What they're talking about is the fact that it's testimonial.
Well, it's testimonial, but in the context of what the purpose of the Sixth Amendment right to confrontation is about. And Melendez-Diaz, because one of the arguments that was raised in Melendez-Diaz is, hold it, these test results, this is the product of neutral.
Softball question.
Yes.
Mr. Mercer. It really is a softball question, okay? I didn't realize that we were going to get into this in this.
I agree with you.
You don't need to go there. So you and I are definitely not communicating, but you really don't need to go there, okay? I think that this whole case doesn't need to go into.
Yeah, you're just using them as illustrations of what can happen and why there's a need
Yeah,
for cross.
exactly. That's all. It's just an illustration. I don't want to digress into all of those examples. I think when I talk about the functional purpose of the Sixth Amendment, that clearly it's a truth-seeking device.
For purposes of clarity in this case, when you use the term raw data, what are you specifically referring to?
Well, there were, in the context of the DNA analysis, the argument that's being advanced that the raw data is the electropherograms. That's what was introduced at trial, were the sort of squiggly printouts that look like
You're not including anyone's opinions within that raw data. That's
well,
something extra.
And that's a distinction that is without a difference here, because the point is that, and that's the distinction the State makes, is that, well, there's no opinion and there's no conclusion from the non-testifying analyst. But the point is, the question is whether the raw data itself is a testimonial statement, those squiggly lines, the electropherogram. And what is abundantly plain from Crawford and its progeny is that there has to be a functional assessment of whether that information generated in anticipation of prosecution is fulfilling the same function as if that witness came in to testify.
If we agree with your argument, I don't mean to interrupt your answer, but if we agree with your argument, do we have to overrule Rollins versus the State?
I think
Or
Rollins...
can it be distinguished?
Rollins, I do not believe, is going to survive Melendez-Diaz, because Rollins, the distinction that was made in Rollins was that these are objective facts contemporaneously observed, for example, the size of a cut or laceration. And merely because it's a fact as opposed to an opinion, it's still a testimonial statement.
Well,
and if it's
there's an issue, I suppose, in this sense. I think there is a distinction, and I think Melendez-Diaz draws it. Or by reading that case, I think somebody can draw a distinction between, let's say, an expert's analysis of a hospital record prepared for purposes of treating the patient as opposed to prepared for purposes of putting somebody behind bars, on the one hand, versus a lab report generated in a police department lab by somebody who's working for an agency that's in the business of enforcing or prosecuting the laws. So with Rollins, there is a statute that says autopsies have to be performed under certain things, and we've got sort of a public record here that allows an expert to come in and interpret non-testimonial statements, I suppose, in a public record. Now, your case, of course, is different, it seems to me, because here we're dealing with law enforcement organizations and employees of law enforcement organizations working on data with a view towards solving a crime and prosecuting the criminal.
Yes, the assessment of whether a statement is objectively made in anticipation of criminal prosecution is going to be fact-specific in an individual case. And there's easy situations like ours where it's the FBI conducting it, and there may be more difficult cases. And the question about autopsy reports is one that has divided many courts. Notwithstanding the fact that there's a statutory duty, if a medical examiner is conducting an autopsy of a corpse that is plainly the result of a homicide, then that would seem to be objective knowledge that any statements generated are for the purpose of criminal prosecution. There was just a recent case that was decided by an intermediate appellate court in Michigan that addresses an autopsy situation, People v. Dendel, and I provided this to the State, 2010 Westlaw 3385552, August 24th. And that dealt with some of the, and it sort of surveys many of the autopsy cases. But quite candidly, Your Honor, I think it's the distinction between, if the distinction is between whether a statement is made as anticipation of criminal prosecution, that's going to be fact-specific. But if it's a distinction between facts and opinions, and the fact being one that is a result of neutral, contemporaneously observed, objective information, I don't believe that's going to survive. That distinction would survive Melendez-Diaz.
Counsel, I've read so many of these cases, although I haven't seen your moment. In Melendez, was that a cold case match?
Well, Melendez dealt with a certificate of analysis of cocaine.
Oh, that's right. That's right. Yeah. Well, does it matter with regard to the confrontation clause analysis whether the particular testing that you're focusing on was to identify a suspect or you already had a suspect and you were trying to close the deal?
Well, and I think that Melendez-Diaz answered that question, that rejected the notion that somehow there's three categories of witnesses, one of which would be these neutral witnesses called by the state to simply establish scientific facts. The point is there's two categories. There's the state's witnesses and there's defense witnesses. And if the state's going to introduce the testimonial statement of a witness, that's against the defendant. In Melendez-Diaz, it was what the substance of it was the result of testing of a substance.
Was that cocaine or not?
Yeah, whether that's cocaine or not.
But they already had Melendez-Diaz as a suspect.
Right, and I don't believe it turns either on whether a suspect has been identified. The question is whether it's made in anticipation of criminal prosecution. Because even if a suspect isn't identified, the same pressures that are brought to bear on a lab analyst to generate a result, here any male profile that is then run through a DNA database is the same. There are still those powerful hydraulic pressures that are brought to bear.
But how does I mean, in a cold case match situation, since they don't know who they're looking for, they take the test results and they get whatever information, and then they look for the match, and it comes up your client.
Well, here's the danger in the cold hit situation, particularly as databases increase in size, is that whatever profile is determined from that analysis of the rape kit, whether it's at a full 13 loci, 12, 11, or 10.
It's 13.
This is 13. Can be run through a database, and then a match can be found. And then whoever that matches to then becomes the defendant. The critical question is, during that analysis of the rape kit, even though there's not a suspect identified, what the analyst is attempting to do is tease out a male profile. It's trying to find a profile. Now, that analyst may, because of the pressure of the lab and the need to generate results, may cut corners, may over-amplify, may try to run the sample through the electropherogram for a longer period of time, all in an effort to...
I don't mean to interrupt you. Your 1 minute light went on. But if we agree with you, let's say we agree with you, you give us a list of the people that should have testified in this case in order to satisfy the confrontation clause. Who goes on that list?
The serologist from 1985 who rendered the opinion about the presence of semen and sperm.
Okay.
And the biologist who conducted the bench work that generated the DNA test results in 2002. And yes, and that's so we're not saying there's more witnesses.
Just those two were the only essential people.
That's
Everybody
correct.
else who had anything to do with any of these testing or retaining or anything like that, the confrontation clause doesn't apply to them.
Right, because the state called the chain of custody witnesses here. They called an expert about the interpretation of the results. What we're simply saying is, rather than calling a surrogate, just call the analyst who did the test. That's how we do it in Maryland courts. Just because this is how the FBI does it, all of a sudden we should be changing how trials are had in Maryland?
You can finish your answer. Had you finished?
Yes, I'd finish that thought. Thank you.
If he has time, you have a
Yes,
question?
go ahead. It's your time.
Okay. As far as the Rule 5703B, which allows the expert or the court discretion to put into evidence opinions and facts and things like that, what happens to that rule under your theory?
Well, that rule can be applied in situations where the evidence or the statements are not generated in anticipation of criminal prosecution. So the classic one would be, as Judge Murphy had referenced, a statement made for treatment purposes. And there, that could come in both as a business record, possibly. That could also come in, if reasonably relied upon, by an expert in that field as well. The problem is that what the state's seeking to do with 5703 is really just use it as an end run and circumvent the Sixth Amendment. And Crawford made clear that the vagaries of the rules of evidence do not overcome the right of confrontation.
Wait a minute, it can't?
Go ahead.
I thought you were saying it could not be used as information that's reasonably relied upon because the confrontation clause overrides that.
That's correct.
Okay.
Yes, absolutely, because
I misunderstood something.
right, and frankly, I think it's somewhat of an artifact, it's an artificial notion of fiction to suggest that information comes in not for its truth. I mean, the jury has to first decide, do I believe that information before they believe the experts? So,
Thank you.
Thank you.
Mr. Taylor.
Thank you. May it please the Court, Robert Taylor on behalf of the State. I'd like to clear up a few things because this is, on its face, looks like a much more complicated case, actually, I think, than it is. And I think on the Sixth Amendment issue, it does get to the heart of the question as to determine whether these statements, whether the raw data generated by the lab technicians constitutes testimonial hearsay or not. Crawford found that there's a right of confrontation applied to those who bear testimony. And Melendez-Diaz found that the affidavits by the lab chemists, that just a piece of paper turned in by the State saying, we tested it and this is cocaine, were functionally identical to live in-court testimony doing precisely what a witness does on direct examination. That cannot be logically applied to the raw data generated by the lab technicians in this case. I invite this Court to look at the record in this case. Look at R 561 to 571. Those are the printouts by the genotyper machine. This is gibberish to anyone. This is not a statement being presented for the truth of the matter asserted. It's not a statement, and it's not being presented for the truth of the matter asserted. It is.
How does the computer get that information?
That computer gets that after different vials bearing solutions that have biological evidence and different chemicals are stuck into, right? And it shoots lasers at the machine and it generates these. Now, I will agree, Judge Battaglia, it really doesn't make any difference whether cross-examination would be useful in this case or not. I don't think that's what the Confrontation Clause is about. It doesn't make any difference whether this is the most error-prone lab ever or a completely error-free lab. I agree that is not a relevant consideration. What is the relevant consideration is whether this raw data is testimonial hearsay. And counsel says, well, this is the State's distinction between facts and opinion. It's not just the State's distinction. Virtually every court, not every, I can think of a couple of exceptions, but nearly every court to have considered the same issue has reached the same conclusion. And I'll point specifically to three cases that I highlight in my brief. One is People v. Brown, which comes out of the New York Supreme Court. One is People v. Williams, which comes out of the Illinois Supreme Court. And one is Smith v. State, which comes out of the Florida Supreme Court. Have all encountered a factual situation very similar to the one here and have all distinguished between the raw data generated by the lab technicians and the expert testimony of the analyst, and have found that.
I remember there was some significant distinction of People v. Brown and the other two cases. It said in Brown, the DNA expert who conducted the analysis testified at trial and was available for cross-examination.
That's right. And that's the same thing that happened here. It was not the person at the private lab, in Brown it was a private lab, who actually ran the test who testified. It was the analyst who looked at the results, drew the conclusions and comparisons, and opined that there was a match who testified. That's the same thing that happened in this case.
Is there a difference, though, between, say, a hospital record and a test run by a police lab. For example, in Baltimore County, Dr. Rudiger Breitnecker for years would, when he examined a rape victim, take specimens that could be used later for comparison. My understanding is they were part of the Greater Baltimore Medical Center hospital records. If the test had been done by somebody employed by the police department, would there be a different approach for purposes of cross-examination?
Not for purposes of the confrontation clause. Either it's testimonial hearsay or it's not testimonial hearsay, and it doesn't really make any difference who has collected the actual statement. The confrontation right has to do with what evidence has the state presented in its particular case. It cannot present testimonial hearsay without being subject to cross-examination. However, that does not mean, and I want to point out the use of the term.
Let's apply Melendez-Diaz facts, I guess, to this. Let's say a case comes up where the person who filed the affidavit in Melendez-Diaz does the analysis, but is unavailable, on vacation. So another lab technician comes in and says, on the basis of what my colleague did, on the basis of the test he ran, the test she ran, here's my opinion.
Well,
Does that present a problem?
That actually gets to the test that I believe this Court should adopt, and that has been adopted by several other jurisdictions. And the best example of that is actually Vann versus Alaska out of their intermediate court, and that is the conduit rule. And the Fourth Circuit has adopted it, too, in U.S. versus Johnson. When the person testifying is offering his or her own conclusions, analysis, and opinions, then that is admissible testimony, even if the basis of those opinions may have consisted, at least in part, of work done by someone else. If, on the other hand, the person simply takes the stand and reads the report and says, I think that this person who did this analysis is a good person, and therefore these seem like good opinions, they're merely acting as a conduit for an out-of-court statement, then it does violate the confrontation clause.
But when you talk about the work done by somebody else, that's different from raw data.
I don't mean it to be. I mean, if there's some confusion, I don't mean it to be different. I mean, when I'm talking about the work done by the lab technicians, I'm talking about generating a list of numbers.
But again, how are those numbers generated? I mean, when you take saliva, it doesn't automatically spit out a list of numbers.
That's correct.
Okay, so
Absolutely.
How do you get from point A, taking the saliva, to point B, the list of numbers?
That's right. The person who comes into court, in this case, Ms. Lutman, testifies that she has compared these two sets of numbers, one that was generated in 2002 and another set that was generated in 2004. Other people worked on generating those numbers.
Okay, so how does one get to the numbers from the saliva?
Well, I don't want to go too far outside the record, but essentially the swab.
I want to talk abstract.
Okay. For example, when it's collected on a swab, as in this perk, they take shavings off the end of the swab, they apply some chemicals to demonstrate that.
Would you know how to do that?
No.
Okay.
But that doesn't make any difference.
See, clearly the machine itself doesn't talk, so the result generated by the machine is obviously not testimonial, as
Right.
you point out. The question is, though, does the defendant have a constitutional right to be confronted with the analyst that put whatever it was into the machine to...
And the answer to that...
And the answer is chain of custody, I suppose. So if the chain of custody is satisfied, you get the chain of custody up to the machine, then somebody else can come in and give us the results of the machine. That's
I mean, Melendez-Diaz clearly says chain of custody witnesses aren't necessary. Part of the problem, of course, is trying to fit an 18th century paradigm on 21st century
Well,
forensic
chain
science.
of custody witnesses are necessary to get a piece of evidence in when you need to establish chain of custody. You don't have to put everybody in the chain
Right.
necessarily.
Right. Right. You
Okay.
just minimally show. What I would use by way of analogy is, how do we know we're on Rao Boulevard? We're trusting the guy who put the sign up at the corner of the street that he put the right sign in the right place. You run into this reductio ad absurdum argument. When the police officer writes down that he saw somebody at 10 a.m., how does he know it was 10 a.m.? We're trusting that the clock was set properly. At some point, all testimony is rooted in hearsay. I only know my name because my mom told me. I mean, at some point, everything, we rely on other information generated from other sources to reach our own opinions and conclusions.
What about the 1985 analysis, male, female, or non-ex...
Right. The 1985 analysis, again, these are, if we accept that Rule 703, or in Maryland 5703, survives Melendez-Diaz, which I think, again, every court to have ruled on the issue has found that to be the case, although I agree with counsel that an evidentiary rule doesn't trump the Sixth Amendment. But if it does, then the 1985 analysis is still admissible because Ms. Lutman testified, these are the sorts of things I rely on all the time to make this conclusion. In the case of the 1985 and all of the other things that I said about an expert who comes in and gives her own opinions and own conclusions would still stand. In the particular case of that, though, I would invite this Court to look at the minimal testimony Ms. Lutman gave that actually used the word sperm or semen in this case and replace it with male fraction, which is what was originally set up in this case. There was a motion to suppress that particular bit, and the judge held it in abeyance halfway through Ms. Lutman's testimony, sent the jury out of the room. They had a hearing on this motion in limine, and the judge agreed that she would allow Ms. Lutman to use that term. But under the facts and circumstances of this case, had she never uttered the word semen, the results would have been exactly the same, because the test itself identifies that there was a Y chromosome in the sample that they looked at. And so the existence of sperm or semen as such is not an element of the crime of rape. In this particular case, he is identified by this male fraction that's found in the rape kit, and the fact that the male fraction actually consisted of sperm, in the end, doesn't affect the expert's conclusions or the identification of Mr. Derr as the person who committed this act. Now, I don't want to I just want to address a couple other things that have to do with the discovery issue and the Arizona search issue. There's a lot of math and statistics thrown in there that are really beside the point. I want to clarify a couple of things. When Mr. Derr in his brief talks about coincidental matches or partial matches, these are not matches. A partial match is a total exoneration. If a DNA analyst looks at it and 5 sites don't match, the fact that 9 of them did, in fact, if 1 of them doesn't match, that's an exoneration. And so when he says that there have been too many examples of 2 persons sharing genetic profiles, that's nonsense. That's never happened. Other than identical twins, there aren't any that I'm aware of. There have been no records of someone having an identical genetic profile. That just does not happen.
Well, isn't that because the tests haven't been done?
No. It's because, and I will refer this Court, and I mentioned this to counsel the other day, to an article that, written in part by the director of the FBI lab, that sort of breaks down why the database search would not actually indicate that one way or the other, which is in the 123 International Journal of Legal Medicine 59. It's a very short article that mostly summarizes the same things that were in my brief. A test to find out how many random occurrences might happen between the people who are in the database, at best, and there are flaws in the reasoning, but at best might address the accuracy of the underlying population statistics. The idea is not to show that DNA science doesn't work. It's only to show that there may be some error in the way that these underlying population statistics were done.
Is that what the Arizona test established?
No, actually, there is some dispute as to, and the secondary literature goes back and forth on this, as to whether that can be adequately explained by what's already in existence or not.
Okay, so if there is a dispute, and the secondary literature goes back and forth, then shouldn't a defendant who's being convicted solely on this evidence have the right to know whether this this assertion there's no match in the whole world of
Well,
your DNA?
The short answer is no. The short answer is no, he does not have that right. Whether there may be a public policy argument for engaging in this lengthy science project with the FBI database is beyond the scope of Maryland Rule 4263. He does not have a right to demand that the FBI engage in a science project, which is essentially what he was asking for.
Or to say, fine, FBI, don't engage in it, but we're not going to either allow that evidence or we're not going, if we allow it to be admissible, we're going to do it under these restraints. I mean, we can't order the FBI around.
By statute, DNA evidence is admissible. The science, this isn't a challenge to the fundamental science of DNA. It's, I want to engage in a research project that maybe, if I'm lucky, might show that the rarity statistics are a little bit different than what the FBI has been relying upon.
If there are 100 people out there who would have the same DNA as measured by 13 loci, out there in the whole world, is it fair to convict someone based solely on that DNA?
Yeah, we're so far into the realm of science fiction at this point, I don't know that I can answer that question.
Well,
I mean, nothing.
Excuse me, it's a hypothetical. Try for me.
If there are 100 people in the whole world, I don't know if we can assign a numerical value to reasonable doubt. What I will point out is this. When Mr. Derr's sample was compared to the millions that were in the database, they didn't get 2 hits. They didn't get 3 hits. They got 1 hit, 1 13-point match.
Without comparing.
That wouldn't change that his was the only match. I mean, if
there's no question that the FBI can't be compelled to undertake a science project. But what if the information is available? What if what the defense wants to know is something that the witness who testified in this case could have shown up with at trial? Wouldn't the judge be at least within his or her discretion to say this witness isn't testifying until this information in the possession of the FBI is furnished to us?
The information that's in question is information that would essentially challenge or at least modify the rarity statistics.
Right.
Okay.
It's just the percentages.
Right.
Yeah.
Just the percentages. The issue becomes, if there is information out there that challenges the accuracy of these, essentially you get into a Fry-Reed situation where now we're testing whether the science relied upon by the FBI or not is reliable enough to be put before the jury. And so without knowing specifically what the results of this theoretical test are, I can't say how a Fry-Reed hearing would come out, but that may be the next step in the process. Candidly, while I know that by statute Fry-Reed is bypassed for the admission of DNA evidence, I don't know if Fry-Reed might still apply to the use of statistics. I'd have to go back and read the Young and Armstead cases. But that's where we would be, is not challenging the admissibility of the DNA evidence, challenging the use of the statistic, and that would depend, again, on
The 1 in a gazillion.
Right. Right.
And in terms of, does that go to the issue of discovery also? I mean, in terms of exculpatory discovery, I mean, evidence? When you were talking about that, I was thinking about, is that exculpatory over which, the trial judge has some authority in terms of ordering the disclosure of?
It is at most potentially exculpatory. And then the analogy I make in my brief is to Arizona versus Youngblood. If the state is not obligated to preserve potentially exculpatory evidence, it's certainly not obligated to create potentially exculpatory evidence, which is really what's being requested here. And again, I can only refer to the academic debate between statisticians as to whether it would actually generate any potentially exculpatory evidence or not. Even that is speculative.
Counsel, one more question. The CODIS has 3 million genomes, right?
Depending on when you count, that's right.
So might be approximately the greater Baltimore area?
There's 8.5 million now, which would be, right, not quite the population of Maryland.
I'm sorry.
Or more, there's 8.5 million, which would be more than the population of
But when
Maryland.
this was, I guess when,
I
got 3 million in the
think
brief, so
2.5 million when the test was done.
3 million people were looked at for matches. That leaves how many people in the country, let alone the world?
That's correct. Nonetheless, the science of DNA, I mean, there is a scientific basis for where these numbers come from. And when you have a number of 1 in 240 quadrillion, many, many, many times the population of the Earth,
That's
it
the
is...
issue we have, is that they use that large fraction, or small fraction, whatever you want to call it.
That's right. As this court...
They didn't say it was 1 in 3 million.
Well, but this court upheld the use of the product rule in Armstead. The issue, the question of should it be modified by the fact that it was done through a database search that asks a completely different statistical question, which is what are the odds of finding our guy in this particular database? That is a question which he was certainly entitled to ask. He shied away from it while he presented that to the expert, that this would be a different question, wouldn't it? And she said, yes, that would be a different question, and that would be a different number. But he never asked for the number. And the reason is his own expert had testified at the pretrial hearing that in a 13-point match, even that modified number is many times the population of the Earth and would still be justified essentially in declaring it to be a match. I will defer to my brief on the other issues.
Thank you, sir. Mr. Mercer?
On the discovery issue, here's the crux of that issue. DNA evidence is inherently probabilistic in nature. And so, for example, in the Derr case, when the FBI expert comes in to testify, and she recounts these statistics that represent, in her definition, the chance of finding that profile in a random population, she makes it out to be an extremely, extremely rare chance. And then on top of that, she also says, and we have never seen a match at 13 loci. Now, our point, I think, at the center of this controversy is if the FBI is going to have this database, and if they're going to use that database to generate evidence, and they're going to introduce probabilistic evidence and then assert that they have never seen a 13 loci match, then we, the defense, should have access to the information to look to see whether there have been 13 loci matches. And the Arizona database study, which was also done in Illinois and also in this state's database, shows that there are these matches that are occurring at a sufficient number of loci that would be otherwise a basis for a source attribution opinion. And so all that we asked for, I did go into the weeds on.
You know, I've taken a number of classes in this area, but Mr. Mercer, I didn't understand a thing that you just said. When you went to source attribution and all of that, can you make it a little bit more simpler for me?
I will, and that is always the challenge with this material.
Making it simple for her old brain?
No. See, now I'm already in hot water with Judge Pataglia. So it's my challenge to put it in plain terms. And
all I'm really interested in is how can an entity be forced to create what you want?
we're not asking them to create. We're not asking them to do a science project. All they have to do is give us a disk with the information on it, and our expert will generate it. This is
the disk of everything they have in their one disk with everything that they have on everybody?
Yeah, what we had asked for was stripped of any identifying information, but was simply
You don't think that that some of these loci could identify male, female, and all of that they wouldn't have some identifying information?
Well, there's generally speaking, there's identifying information, but in terms of personally identifying information, it's stripped of that. And in fact, the statute, both the Maryland DNA database statute as well as the federal database statute, both allow for research to be conducted of the data in the database stripped of personally identifying information.
By a defendant in a criminal case?
Well, generally speaking, it authorizes it. So my point simply is that the privacy concerns are not, I do not believe there are real privacy concerns. I think the real issue here simply is that the FBI continues to assert that there has never been and will never be a 13 loci match, and yet we see in these other, when access has been granted to other databases, we're finding matches at a sufficient number of loci that really call into question these very small numbers that the FBI are saying represent the chance of ever seeing.
Do any of the other
match.
studies show that there is a match at the 13 location?
No, 13 loci, no. That's
always less. You know, and as I understand it, you have to have matches at the 13. You cannot have matches at the 4, 5, 6. So whether you have matches, we could have millions of matches at 4, 5, 6, 7, 8, 9, 10, 11, 12. Well, and they would be thrown out.
Here goes back to my jargon before. It used to be that a source attribution, that is, this person is the source of this biological evidence. Okay, the standard used to be that could be done at 10 or 11 loci. Okay, now the FBI has some other, and it's just a policy that they have.
So you're really wanting the information to show how many loci have been used to identify each individual in the FBI's database. And so isn't that a question, has 13 loci been used to identify each individual in the FBI's database rather than getting the entire database? I mean, isn't that a question that one could ask?
I think the question we were asking is how many matches at 9, 10, 11, 12, and 13 can you find within your database?
But they wouldn't, but that's not a question, because they can't find any matches at other than 13.
Well, no, they can. They can, and that's part of the misinformation here. They absolutely can find matches at lower.
No, matches meaning that it's you, or a match meaning that it's me, because the limit or the amount that's necessary is 13. So the question only is whether they've derived matches from less than 13 when they've given out information saying it's you or it's me.
I guess I put it on me. I don't think I'm communicating this issue well. When the FBI generates a random match probability of, say, and let's say all they have is a 12 loci or 11 loci match, and they generate a random match probability, and I'll just use the example of the Arizona base. They generate a random match probability of 1 in 760 million that you would not see this profile again if you went out and you looked in this population of people. 760 million people, you wouldn't see it more than once. And yet in the Arizona database, there was a match at 9 loci between an African-American male and a Caucasian male.
At how many?
At 9 loci. Now, so
does the FBI have control over how they determine that it's 13 as the gold standard?
Well, the FBI set 13 as the number of loci that they scientifically thought was appropriate for inclusion in their database.
And do we know what the basis of that determination is?
Well, it's based on their own statistical studies.
It's not just the FBI. This is international, right?
Well,
the literature in the countries that have the sophistication to do this, they've been triangulating over time. How many loci is it going to take to reach the gold standard? and when they thought it could have been 5 or 6, and they failed because there were multiple matches. That's the information you were asking for.
Yes.
Show us the failures in the evolution of getting to 13 loci.
Yes, and whether there are matches at 13.
Do you know of anything in the literature internationally that says there are multiple matches at 13 other than identical twins?
Well, I think our point, well, if we talk about relatives, yes. But the point is, but that is the point, isn't it? That if this is probabilistic, and if they have that information in their database, then, and they're asserting that there's no matches, then why shouldn't it be verified? That's all. I mean, that's really just the crux of it. But let me, in the limited time,
Yeah, go ahead.
Let me go back to what's really a central issue here, which is the Confrontation Clause point. And first of all, on the harmless error of the semen and sperm, it's very important to note that it was very necessary for the state to establish that it was semen and sperm for the simple reason that it would rebut any suggestion that samples had been contaminated or that the DNA on the swab that was a male DNA was from whoever was handling the swabs back in 1985. So it's not harmless for those opinions to come in, and the state essentially concedes that the opinion of the serologist is testimonial. They dispute that the raw data, the electropherograms from the DNA analysis, are testimonial. And here's how the state characterizes it. They say the problem is trying to put modern technology into an 18th century paradigm. I presume what the state means by that statement, the 18th century paradigm, is the Bill of Rights. I don't believe at all that it's difficult when you look at the Sixth Amendment and the function that it serves, that it's difficult to review what's happening here and the testimony about the DNA analysis that requires the input of a person to generate a result, that requires a person to exercise discretion and judgment, that the output of that machine should not be deemed the testimonial statement of that analyst. That's the only logical way ultimately, in view of the function of the Sixth Amendment, to view it. And the right of the confrontation, as the Supreme Court said in Pointer v. Texas, and cross-examination is an essential and fundamental requirement for the kind of trial which is this country's constitutional goal. Mr. Derr did not receive that trial.
Thank you all.
All right.